Hey, welcome to On the Chain. This is Jeff here on the Huddle Review. We are going to talk today about the SEC v. Ripple lawsuit actually proving the need for regulatory clarity more than ever before. Has a court case ever shown that where we stand today with this brand new asset class, that there's a need to advance legislation like the Token Taxonomy Act through Congress, through the Financial Services Committee, and provide the guidance that's necessary to allow the development of this technology. Never before has a court case been so critical. Let's talk about that, maybe a little bit more. Let's go.
And now, the Huddle Review with Jeff on the Chain.
All right, welcome back. So yeah, SEC v. Ripple. We could look at it from so many different perspectives. You can tear into the legal aspect of it, get some real understanding. I'm going to look at it from the legislative perspective. So right now we sit with very little to no true regulatory clarity. The SEC reacts based on legislation that's on the books. So the SEC can judge a company, can judge the technology of the company, can judge the asset class, this brand new asset class, digital currencies, cryptocurrency, and is going to judge it based on legislation that has been on the books since 1933, 1934, and beyond. We're talking about the Securities Exchange Act and the Securities Act of 1933 and 1934. We're talking about years. 1946 was the Howey test. It was the test. So it took 13 plus years, 12 or 13 years, for a court case to actually show some guidance moving forward, providing some clarity based on a court case outcome of how to judge companies based on the Securities Act of 1933 and 1934. And so as you move forward through the years, the SEC still judges companies based on that outcome. I joke around, I talk about the lemon tree, and that we're selling plots on the lemon tree, that we're going to harvest the lemon tree and water the lemon tree and take the lemons to harvest, just like the Howey test, except it's different. It's one tree, they're lemons. You get the idea. So in this scenario, though, the SEC is coming after Ripple like they did after Kick, and now they're suing Library, and they're going to come after many other cryptocurrency or blockchain companies because based on their concept of how they read the law from 1933, 1934, and a test on the book since 1946, they want to judge a company based on that terminology. Now, what does a technology company and a digital asset have to do with oranges and orange groves? Now, you can look at company structures and the test, and you can dig in and say, does it meet all the standard qualifications of what the Howey test represents? And many have said it doesn't. Yet the SEC says it does. So a lawsuit's filed, and I think the lawsuit is actually critical. It's probably one of the most important cases right now from the financial perspective when it comes to blockchain and technology. The outcome of which can help stimulate the advancement of the regulatory clarity that's required. And on the live stream, I was saying regulatory clarity and regulation can really be looked at differently because regulation can be very punitive. Regulatory clarity is providing a map, the rules of the road, so to speak. So if we're going to look at regulatory clarity, it's the road, the lines on the road, the traffic lights, the rules of which we all drive on the road. Regulation is when they put punitive damages, like a red light camera at an intersection that captures your car when you go through the red light or the yellow light. Whether it works or not, you don't know, but you get a ticket in the mail. A very punitive action on top of the regulatory clarity of how we are supposed to work on the road. We know we're not supposed to go through a red light. So, in this scenario, that's just simple the way I'm thinking about this. But in this case, we have cryptocurrency and blockchain companies and the ideas of how you get these digital assets into the hands of the people, whether it was through the ICOs, which they deemed problematic, and to the extent where this case, SEC v. Ripple, the attorneys on the SEC side have in some way used a little bit of a reckless abandon in coming after Ripple. Some of the claims, some of the statements that have been made, and so forth. Just checking, my computer just shut off, so I might freeze momentarily. I might have frozen. So it's really interesting to see exactly, how this case has kind of been progressing, but it's needed. It's so necessary. And, how Ripple responds to it. Now, the SEC has gone so far as to ask for legal guidance provided by Ripple's lawyers. And the SEC actually wants those documents. Now, I'm not sure. I've been trying to investigate to try to determine where these documents, at what point in time this was written. I know I read someplace, and I'm digging through and trying to find it, where the attorneys gave, back in like 2012, gave some commentary to Ripple at the time and said they think it could possibly be a security, XRP, but they weren't sure. Now, if we're talking about those letters and that guidance and that conversation that the SEC wants, then we're talking about an antiquated conversation. You're talking about a conversation from a time that the SEC themselves had no idea what cryptocurrency, digital asset, or blockchain even was. Most lawyers had no idea even how to analyze it or look at it or interpret it. They couldn't provide any real concrete guidance. 8 years later, we're still in a position where there's no regulatory clarity. We're still operating off of this premise of legislation from 1933, 1934, and the Howey test from 1946. So the SEC still continues down this path. While all of this is going on, you have actual legislation sitting in Congress called the Token Taxonomy Act that has been there the third time in a row, sitting at the Financial Services Committee, the one bit of legislation that can actually do something to amend the acts from 1933 and 1934. And we're talking about 80 plus years ago. So we want to amend it, bring it up to date, give a little guidance, even from a tax perspective. What's considered a taxable event? Right now, nobody knows. It's first in, first out. Everything's a taxable event. Every bit of gain, even though you're moving currency, it's been identified, it's been recognized that some of these digital assets are indeed currencies in other countries. Go to Japan or England or Australia or Switzerland. Go around the world and they look at XRP as a currency. They look at Bitcoin and Ethereum and others. And they tax them in a different manner. In the US, however, there's zero regulatory clarity. And it leaves the SEC, or it leaves this whole idea very subjective to the whims of the SEC to make determination based on their opinion. Now, the SEC isn't there to write legislation. They're there to act on legislation that is on the books. They're there to use the guidance of these acts that are legislated by Congress, passed through the House and Senate, and then signed by the president. That's how it's supposed to work. Now, in this scenario, obviously the SEC has a couple choices. They can provide more opinion, or like they did with Ripple, they bring them to court and they say, okay, let's go. Now we got to make a decision. To me, I think it was time, because if we're not going to get regulatory clarity in Congress, we need regulatory clarity somehow. And the SEC, now we're sitting there in this scenario where the SEC is suing Ripple, obviously. And if you go online, let me pull up. I'll just pull up my, see some of my notes. So some of the ideas that I had put together. But if you go online, you search it up, lots and lots of articles written about XRP, unregistered, a security, not a security. It goes on and on. And in fact, if you go back to Giancarlo, he was the former chair of the CFTC. He said XRP isn't a security. Now, isn't this interesting? So this was in June of 2020, this article was written. Problem is, at this point in time, he wasn't the chair of the CFTC, the Commodity Futures Trading Commission. The issue with this is Gensler, who's now the chair of the SEC, also chaired the CFTC. I think it was in 2014 or 15. He has a different opinion. So now it comes down to opinion. And it comes down to the politics of it all. So Giancarlo obviously can act freely now. He's no longer in office. But he was the chair of the CFTC. He did have a certain thought process. Gensler also is not the chair of the CFTC any longer. He's now the chair of the SEC. But he doesn't share the same philosophies and opinion as Chris Giancarlo. So now you can see the problem. So you have two chairs of the CFTC. One is saying that XRP is not a security. Another is, in his current role of the SEC, has to follow through with a lawsuit that was filed by the SEC. He wasn't in office as chair when the suit was filed, but he is now. Then he comes out and makes some statements, some claims, talking about Gensler, that a lot of cryptocurrencies are securities. Now, he didn't have to come out and state it based on that fact, like that, or as fact. He could have said that we need to investigate, we need to determine, there's all these things going on, but let's see how the outcome of this case is going to be. The SEC v. Ripple. Maybe he can't say that based on where his current position. He can't come out and make statements like that. However, we have seen others like Hinman and Clayton and even Hester Pierce coming out and making statements. In fact, we heard Clayton and Hinman both make statements alluding to the fact that Ethereum and Bitcoin are not securities. But that was based on opinion and their personal opinion. It wasn't done as a direct professional representative of the SEC, as has Hester Pierce made certain statements. So maybe in their professional position, they don't have the same feedback. But here we sit with this case right now, SEC v. Ripple, and you can see the complexity based on the fact that two previous chairs of the CFTC disagree. We see that within the SEC, there isn't a true or a clear vision of guidance because there's no legislation. The outcome of this case can help pave the way for regulatory clarity, and it highlights and underscores the need for clear legislation and underscores the need for legislation like the Token Taxonomy Act. And we are going to cover that and more with Congressman Warren Davidson on our live stream May 13th. So if you're watching this after, go drill down to our other channel and you'll find it. I hope you enjoyed today's talk, conversation, ideas, opinions of mine. If you like that, give a thumbs up, leave some comments below, hit the subscribe button if you're brand new to On the Chain. And check us out on the other channel because we do stream 6 days a week, Sunday through Thursday at 8 p.m. Eastern Standard Time and every Saturday morning at 8 a.m. Eastern Standard Time. It's a pleasure being here with you today, and I'll look forward to seeing you on the next one.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.